Hi, everyone. This is attorney Arkady Frekhtman, a New York City personal injury trial attorney. And today we're talking about settlements. How do you settle a personal injury case? And specifically, I wanted to answer two questions that were left in the comments by viewers. The first question asked, it basically said that a lot of lawyer videos talk about the final settlement amount, but they don't talk about the process. What was the initial demand? They asked about the demand letter. What were all the settlement amounts along the way? What did the lawyer ask for in the beginning? And what was the back and forth? And how did it end up at the final settlement amount? And the other question asked whether initiating a settlement conference or initiating any kind of settlement, starting the settlement process, can be taken as a sign of weakness. So let's talk about these questions. I think they're both really good questions. And I think the best way to answer this question is to really break it down in terms of the type of case that the lawyer is handling. So if the lawyer is handling a small case, let's say a case that the lawyer does not want to take to trial because the lawyer feels if they take this case to trial before a jury, they may lose, or it may not be worth much. That type of case, the lawyer should settle and the lawyer should write a settlement opportunity letter. I don't like the word demand. I don't know, to me, demand makes it seem like I'm demanding, like I'm begging, and I never want to be in that position, even if I'm handling the worst case. I just like the idea of settlement opportunity. So I'll send a settlement letter on a small case. Let's say I have a soft tissue case, like a car crash, good liability, really soft tissue. The person goes for treatment for like 2, 3 months. They might have a bulging disc. They don't want to do anything. They just did very, very basic stuff like chiropractic, nothing else. So, the case is probably worth like anywhere from maybe 10,000, maybe a little less. Some cases even settle for 7, 6,000, maybe a little bit more, like 15, 20, but that kind of case. So how would I approach it? If I wanted to get it settled, I would first, make sure my client is done with all the treatment. I would get all the medical records, send a settlement package with the medical records to the adjuster, give the adjuster about 2, 3 weeks, call the adjuster and say, look, your policy is 100,000. My client's been treating. How about we settle this? My initial settlement amount is 35,000, and the adjuster will say, "Oh, okay, I'll give you like 4,000," and then you just kind of try to work it up as much as you can. If you can get them to 10, 12, you probably want market settled. As long as the client agrees and they're happy with that, you can market settled. So that's how I would do it in a small case, right? A case like that. And basically, I would start high. I wouldn't start at 10, because if I start at 10, there's no way I'm going to get more than 10. There's no way I'm probably even going to get 10. I would start at like 35, 40. You don't want to start too high, right? Because if you start, give me 100,000, and then they're like, oh, you're asking for 100,000 on a case where you just had 2, 3 months of chiropractic visits, acupuncture, massage, nothing else. It's not worth that, right? They have a history of all the other cases. People settle these cases for like 5,000 and less. And a lot of them could be no threshold because they don't meet the serious injury requirement, which is something we have here in New York. And I've done other videos about that. So you see, if you start too high, then you can turn the adjuster off. They could say, oh, forget it. And that happens in other cases too. Sometimes you might have a good case, but you might say, what's your demand? They want to know how much you are asking for. And if you respond and you say, okay, let's start off at like $6 million. Like $6 million. Oh my God. We never evaluated the case like that. We thought the case was worth, the most, 200,000, and our first offer is 10,000 because your demand is so crazy, or we're not gonna give you any offer against that kind of a demand. You see, so you probably don't want to start too high. So usually, a lot of lawyers will say rule of 3, so it's like 3 times what they're trying to get. So if they're trying to get 10,000, they'll ask for like 30, 35, 40 in that ballpark. You can go a little higher, like 50, but because you're trying to get a third of what your initial settlement amount is. So your initial settlement amount is like 35, and you're trying to park the case at like 12, 15, that's like your end, right? That's like the end zone. That's what the end result, the final amount that you're trying to get. So that's on the smaller cases.